Yeah, start please.
Shall I start, ma'am?
Yes, yes.
Good morning, everyone. Myself, Ganesh. I am studying the final year LLB in Sagar Gangotri College of Law, which is located in Sagar. My seminar topic is analysis of memorandum of association and articles of association. I will start now. First of all, I am going to analyze the memorandum of association. Companies are generally formed to earn profit from business activities. To incorporate a company, an application has to be filed with the registrar of the companies. The application required to be submitted with a number of documents. One of that very much important document is a memorandum of association. And now we will move to the definition part of the memorandum of association. The definition of memorandum of association is given under section 2 subsection 56 of the Companies Act 2013. It states that memorandum of association involves two things, which are the memorandum of association as originally framed. It refers to the memorandum as it was during the incorporation of the company. While the incorporation of the company, the memorandum, the original memorandum of association, which is created, that one. The another thing is the memorandum as altered from time to time. It means the all the alteration that are made in the memorandum from time to time will also be part of the memorandum of association. This means the alteration part of the memorandum of association also be considered as the memorandum of association. By this definition, we cannot understand easily what is the meaning of memorandum of association. Now we will move towards the meaning of memorandum of association. The memorandum of association is a legal document. It's a basic legal document. It's a very important document which describes the purpose for which the company is framed. It defines the powers of the company and the conditions under which it operates. It is a document that contains all kinds of conditions and governs company's relation with the outside world. It is very important. Memorandum of association governs relationship with the outside world. Very importantly, I am quoting this. Next point is purpose of memorandum of association. The main purpose of the memorandum of association is to explain the scope of the activities of the company. What are the activities that should be mentioned? This is the very important objective or purpose of the memorandum of association. Next part is clauses of memorandum of association. This is very important. These clauses can be considered as the part of the memorandum of association. The memorandum of association is created with different clauses. We can say this as the classifications of memorandum of association. We can say like this: the internal parts of the memorandum of association is called as clauses of memorandum of association. Its very first clause is the name clause. The company, being a separate legal entity, must have a name. The name of the company establishes its identity and symbol of existence. The name of the company should not be identical with or should not too nearly resemble to the name of the another registered company. For such a name may be declared understandable by the central government. The word limited must be used at the end of the public company, and private limited is used by a private company. This is very important. Without name, company cannot be existed. The name which we are giving to the company should not be resembled with the name of the another registered company. And another thing is the word limited must be used at the end of the public company, and private limited is to be used for private companies. The second clause is registered office clause. This provision is given under section 12 of Companies Act 2013. The registered office of the company is to be situated. Every company should have a registered office, the address which it should be communicated to the registrar of the companies within. The place of the registered office can be intimated to the registrar within 30 days of the incorporation or commencement of the business, whichever is earlier. This clause is explaining regarding the registered office of the company. The another object is the third clause is object clause. This is very important clause. The object clause is also considered as the preamble of the company. Section 4 subsection C of the Companies Act 2013 deals with the object clause. It states the purpose for which the company is formed. This is very important. The object contains both the main objects and matters which are necessary for the achievement for the company. The object also known as incidental or ancillary objects. This is about the object clause. Next clause is liability clause. The liability clause provides legal protection to the shareholders by protecting them from being held personally liable for the loss of the company. We can divide this liability clause into two things. First one is limited by shares. Section 2, subsection 22 of the Companies Act 2013 defines a company limited by shares. In a company limited by shares, the shareholders only have to pay the price of the shares they subscribe to. Here we can understand easily. We have to pay certain amount for purchasing of the shares of that particular company. Second one is limited by guarantee. It is defined under section 2 subsection 21 of the Companies Act. A company limited by guarantee has members instead of the shareholders. This is all about the liability clause. Next clause is capital clause. This clause states the total capital of the proposed company. The division of the capital into equity share capital and preference share capital should also be mentioned. The number of shares in each category and their value should be given. This is about the capital clause. Next is association clause. This clause contains the names of signatories, to the memorandum of association. The memorandum must be signed by at least 7 persons in the case of public limited company, and by at least 2 persons in the case of private limited company. This is about the clauses of memorandum of association. We can understand memorandum of association as we can compare into a charter or constitution of a country to the company. Memorandum of association works as the constitution of a country for compared to the company. Next part is alteration of memorandum of association. Section 16 provides that the company cannot alter the conditions contained in the memorandum, except in the cases and in mode to the extent as expressly provided by the Act. It is very important that the alteration cannot be done regarding to the conditions concerned to the memorandum. A memorandum can be altered in regard to the name of the company, the place of the registered office, and its objects, its capital, the rights attached to the different clauses of shares by the memorandum, the limited liability of its directors. These things can be altered. The conditions of the memorandum of association cannot be altered easily. Any change in various clauses of memorandum may have an adverse effect on the parties connected with the company. That should be communicated to the members of the company and the subscribers of the company. Next, we are moving towards the case laws regarding the memorandum of association. The first case lies Ashbury Railway Carriage and Iron Company Limited versus Ritchie. This is basically a Europe-based case law. It was happened in 1875. The Ashbury Railway Carriage and Iron Company Limited was incorporated under the Companies Act 1862. The object was to make, sell, or lend or hire railway carriage and wagons and all kinds of railway plants and fittings, machinery and rolling stock, and to buy or sell such materials on commission or agents or as agent. Company agreed to give Riche a loan and build a railway. Company agreed to give Riche to loan to build a railway. At later, the company denied the agreement. So later, the company denied the agreement which was done with Riche. Riche sued and the company pleaded that the action was ultra virus. The issue was whether this contract was valid or not. We should understand before knowing the judgment what is the meaning of doctrine of ultra virus. This is a very important thing. The literal meaning of the doctrine of ultra virus is acts done beyond power, which is not in the power. An ultra virus acts The ultra-virus act is void, cannot be ratified by the directors even if, if they want to ratify it. This doctrine was particularly introduced to protect the interest of the creditors and the shareholders. The object clause is considered the preamble of the company, and therefore anything was done which is inconsistent with the preamble will definitely be termed as void. The acts which considered as ultra-virus cannot be ratified uh, like this. It was held, the judgment, it was held that the contract was ultra-virus. The memorandum of the company thus void and cannot be ratified by the members. Here we can understand the word ratify as moving forward or agreeing to that. This in this case, the act was considered as ultra-virus and it cannot be ratified. The second case lies Evans versus Brunner Mond and Company. In this case, the company was incorporated for carrying on a business for manufacturing chemicals. The company may be incidental for the fulfillment and also authorized to distribute a certain amount of money from the surplus to any university in the United Kingdom for promoting scientific development and research. In this case, it was held that the expenditure authorized by the company was necessary for the company's continued progress, and therefore this act was not ultra virus. This was given in the memorandum of association, so this was not considered as ultra virus. And the next, we are moving towards the analysis of articles of association. We are now here to analyze the articles of association. The articles of association of a company are that which prescribes the rules, regulation, and the bylaws for the internal management of the company, the conduct of its business, and a document of promote significance in the life of a company. We will move towards the definition part of articles of association. The articles of association of company defined under section 2 subsection 5 of the Companies Act 2013. It defines that a company originally framed or altered from time to time in pursuance of any previous company law or of this act. It simply defines that the original articles of association and the altered part of articles of association also considered as articles of association. We are moving towards the meaning of articles of association. It is very important that articles of association contains bylaws that regulate the operations and functioning of the company, like appointment of directors, handling of financial records, and it contains the powers of directors, officers, and the shareholders to voting, etc. The mode and form in which the business of the company is to be carried out, the mode and form in which the changes in the internal regulations can be made, etc. These are about the meaning of articles of association. Next point is objectives of articles of association. Section 5 of the Companies Act 2013 states that the articles of association must include the regulation for the management of the company. It is very important that articles of association should contain the regulations. The contents of the articles of association. What are the contents to be involved in articles of association? Is share capital, lien of shares, calls on shares, transfer of shares, transmission of shares, forfeiture of shares, surrender of shares, conversion of shares in stock, share warrant, alteration of capital, general meetings and proceedings, voting rights and the members, directors and their appointments, dividend and reserves, accounts and audits, borrowing powers, winding up. These are the contents to be involved in the articles of association. Here we can see there is a provision for entrenchment. The articles of association may contain entrenchment provisions. The word entrench means to establish an attitude or habit or belief so firmly that change is very difficult. The company has the direction to include entrenchment provision in its articles of association. Next point is alteration of articles of association. Section 14 of the Companies Act 2013 permits a company to alter its articles, subject to the condition contained in the articles of association by passing a special resolution. This is very important. By passing a special resolution, the articles of association can be altered. This power is extremely important for the functioning of the company. Next, we are moving to the differences of articles of association between the Companies Act 1956 and the Companies Act 2013. There are no major differences, but we can have certain differences in the section parts, and we are and there are certain sections which are given in 2013 Act 13 Companies Act. I am mentioning that in section 6 it is given act to override memorandum of association, etc. Under section 14 it is given alteration of articles of association. Section 7 tells about the incorporation of the company. Section 9 tells about the effect of the registration. Section 10 tells about the effect of memorandum and articles. And section 17, which describes about the copies of memorandum and articles of association to be given to members. Section 15, alteration of memorandum or articles to be noted in the copies. Now I am moving towards the differences between the memorandum of association and articles of association. This is a very important thing. The very first difference is memorandum of association defines the object for which the company is formed. Articles of association are the rules of internal management of the company. They indicate how the objectives of the company are to be achieved. The second difference is this is the main document. Memorandum of association is the main document of the company and subordinated to the Companies Act. Articles of association is a subsidiary document. It is subordinated to both memorandum of association and the Companies Act. Third difference is memorandum of association defines the relationship of the company with outsiders, while articles of association defines the relationship of the members and the company. The next difference is the acts beyond the memorandum of association are invalid and cannot be ratified even by a unanimous vote of the members. The acts beyond the memorandum of association considered as invalid, but acts which are beyond articles can be ratified by the members provided they do not violate the memorandum. The next difference is the alteration of memorandum of association is quite difficult, but the alteration of memorandum of articles of association can be done by a special resolution. Next, I am moving towards the case laws of articles of association. The first case law is New British Iron Company case. In this case is basically related to the European case. In this case, it was held that the article is not itself a contract between company and the directors. It is not about the contract between companies and directors. It is only the part of contract constituted by articles of association between members and company. The directors were entitled to rank as ordinary creditors in respect of the remuneration due to them at the commencement of winding up. It was held in the case of a New British Iron Company case. The next case lies Naresh Sanyal versus Calcutta Stock Exchange. In this case, the Naresh Chandra Sanyal had fully paid up shares in Calcutta Stock Exchange Association Limited. Since he was a member of exchange, he had received explicit permission to carry on his own business in the exchange as a broker. He was a broker in Calcutta Stock Exchange Association. The issue was alleged articles of association of Calcutta Stock Exchange Limited invalid and ultra virus. Whether the Naresh Chandra was liable to pay the damages caused. This was the issue. It was held in the High Court that the exchange was entitled to retain the balance and all the liabilities related to the Naresh Chandra Sanyal had been made even. It was held in the case of Naresh Sanyal. It was the judgment came in favor of Naresh Sanyal. Now I have come in the conclusion part of this seminar. I can say that the memorandum of association and articles of association are very important documents. Without these documents, a company cannot run. So the provisions which are given in the act should be followed in the memorandum of association and also articles of association. Memorandum of association is subordinated to the Companies Act, while articles of association is subordinate to both the memorandum of association and the Companies Act. So the provisions should have to followed strictly. Otherwise, it is going to be a problem to the company. So by these words, I am concluding this seminar.
Thank you so much, Ganesh. It was really insightful. Any questions from anyone? Any questions? No, I don't think there are questions. It was really good. It was really insightful. You covered everything, like what is AOA, what is MOA, what is the difference, what is the act, how to do the amendment. It was really good. Thank you so much for kickstarting the presentation. It was really very nice. It was really informative. And yeah, do we have anyone else presenting today? ಯಾರಾದರೂ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರಾ ಇವತ್ತು? ದಿನೇಶ್ ಅವರೇ ಮಾಡ್ತೀರಾ ಇವತ್ತು? Okay, I don't see anyone presenting today. No issues. We will take the presentation next week or next Saturday or something like that. Okay. So thank you, Dinesh. Merry Christmas, everyone.
Thank you, ma'am. Same to you.
Yeah. Thank you.